I never thought I'd have to defend my right to live on my own land. But that's exactly what happened when a woman named Karen decided she had authority she never legally possessed. It started with a certified letter in my mailbox. Bold red text across the top read, "Final notice, HOA violation." I actually laughed. Not because it was funny, but because it was ridiculous. I don't live in her HOA. Not technically. Not legally. Not in any way. My property sits just outside the subdivision boundary line. When I bought this land 5 years ago, I was careful. I reviewed the county plat maps, checked deed restrictions, and even hired a real estate attorney to confirm the parcel was excluded from the homeowners association. It was no dues, no covenants, no architectural committees. That independence is exactly why I bought the place. So when Karen, president of the subdivision's HOA and self-appointed ruler of trimmed hedges, claimed I owed $8,400 in back dues, fines, and aesthetic penalties, I knew this wasn't a clerical mistake. It was a power grab. Karen had always hated my property. My gravel driveway instead of concrete. My workshop instead of a 3-car garage. My pickup truck parked outside instead of tucked neatly away. And apparently, my American flag flying high didn't fit her community harmony. She had confronted me once before. 3 months earlier, she walked onto my land uninvited. Clipboard in hand, she started lecturing me about maintaining neighborhood standards. I asked her a simple question. What neighborhood? She didn't appreciate that. To her, if she could see my house from the subdivision entrance, she believed she had jurisdiction over it. It didn't matter that the legal boundary line ran 20 feet before my fence. In her mind, visibility meant authority. So she escalated. The lawsuit arrived on a Tuesday morning. She filed in small claims court, alleging unpaid dues and willful refusal to comply with HOA governance. I read the complaint twice. Then I smiled. Because Karen made one massive mistake. She assumed intimidation works on everyone. What she didn't know. I'm a land surveyor by profession. Boundary law isn't just something I understand, it's what I do for a living. And I keep detailed records. Court day came quickly. Karen walked in looking confident. Designer blazer, folder full of printed emails, and 2 HOA board members behind her like silent supporters. She leaned toward me before the hearing started. "You should have just paid," she whispered. I didn't respond. When the judge called the case, Karen went first. She delivered a polished speech about protecting property values and maintaining uniform standards. She presented photographs of my property, photos she had taken while standing past my fence line. Then she claimed my parcel had been automatically annexed when the developer expanded Phase 3 of the subdivision. That's when I stood up. "Your Honor," I said calmly, "may I present the recorded county plat and deed exclusions?" The judge nodded. I handed over 3 documents. The official subdivision boundary map. The county assessor's parcel identification record. And a certified developer filing explicitly excluding my parcel from HOA jurisdiction. The courtroom went quiet. The judge studied the paperwork carefully. Then he looked at Karen. "This property is not part of your association." Karen blinked. She tried to interrupt, saying there must have been a misunderstanding about the expansion. The judge raised his hand. "The recorded boundary clearly excludes this parcel. There is no annexation document. You have no legal standing to impose dues or fines." In that moment, the confidence drained from her face. But I wasn't finished. "Your Honor," I continued, "I would also like to submit evidence of repeated trespassing by the plaintiff." I placed printed still frames from my security cameras on the bench. Clear timestamps. Clear footage. Karen walking past my fence, taking photographs. The judge's expression shifted. He said firmly, "You may want to reconsider your position before this escalates into a counterclaim." 3 minutes. That's all it took after I stood up. Case dismissed. Karen tried to call it administrative confusion. The judge didn't entertain it. Outside the courtroom, she avoided eye contact. A week later, the HOA newsletter went out claiming there had been a boundary clarification. Not a failed lawsuit. Not harassment. Just clarification. But word travels. Several homeowners in her subdivision started asking questions. If she could attempt to sue someone who wasn't even a member, what else had the board been overstepping? Questions about dues increases. About selective enforcement. About where the money was going. Apparently, transparency isn't as comfortable as control. I never wanted conflict. I bought land outside an HOA specifically to avoid it. I like my gravel driveway. I like my workshop. I like not asking permission to exist. But when someone tries to drag you into their jurisdiction without legal authority, you don't panic. You bring documents. Because property lines aren't opinions. They're law. And 3 minutes in front of a judge was enough to remind Karen of something she should have known from the beginning. If you don't own it, you don't control it.